of Parliament arsonist Zandile Mafe will know on Friday if the Cape Town Regional Court will release him on bail. Mafe has pleaded not guilty to the charges he is facing, which include terrorism, arson and theft. Joining us now to discuss how this case is unfolding is legal analyst advocate Romeo Nthambeleni. Advocate, thank you so much for your time and thank you for joining us.
Good morning and to the viewers, and thank you, Douglas.
Now, the bail hearing stretched out for several hours yesterday, wrapping up pretty much just before 8 p.m. The state, for much of its argument, seemed to fixate on the applicant's failure to prove the existence of exceptional circumstances. Now, in bail hearings, when does one have to prove such a condition, and how much of that is weighed by the presiding officer?
Yeah, thank you very much for that question, because bail is regulated under Chapter 9 of the Criminal Procedure Act, with specific reference to Section 58 and Section 77 of the Criminal Procedure Act. Hence, you saw that on the side of the state was proving that there are no exceptional circumstances that are met by the accused to be actually released on bail. And on the other side, you saw that for the accused, they were actually painting a picture that the accused is not a flight risk and he has met the conditions to be released on bail. And I think that is where the argument actually based for the general part of the day.
Right. I mean, part of Mafe's defense team was hard-pressed to, stress, or at least to put across to the magistrate, that the abuse of Zandile Mafe's rights, the fact that he was detained for 27 days without being given an opportunity to actually apply for bail, that this was in fact an unfair limitation of Zandile Mafe's right to freedom of movement and in some way contributed to the exceptional circumstances that are currently before the court.
Yeah, you're right, because I think they were trying to meet the requirement of Section 33 of the Constitution of the Republic of South Africa in relation to freedom of right of movement and rights of the accused persons. And I think they might have found favor in relation to that. And again, another picture that was being painted is that the accused person has an address, he has got a fixed address, and it was also shown that he has properties and apparently is also paying some subscription of cable television. And I think that was just a creation of actually indicating that he has an address, because that is one of the important requirements of satisfying, showing the court that if granted bail, this accused person will be able to attend court. That is a very, very, very much important requirement. So I think a picture was already painted out that the accused does not have an address and doesn't have a home, and he was staying in the streets of Cape Town. And I think that was important for them to show that in case the argument find favor that he's released on bail, he will be able to attend court.
In your experience, advocate, given the fact that the accused was able to satisfy the court in supplying the court with information about his residence and in some way prove that he wasn't in fact at flight risk, would that be enough, to kind of give the presiding officer the impetus needed to grant the accused bail, even though the accused in some portions of his interactions with the state prosecutor did seem to be frustrating the state prosecutor's line of questioning?
You're absolutely right. I think, now to be honest, bail is not a rocket science. I think he might have definitely met the test. And then although, as you are saying, there was a bit of discrepancies in terms of his statement and what was actually shown out in court. But if the threshold has been met, I think the only thing that the state can fall back on is the making of the conditions to be more strict in terms of maybe him reporting to a police station when he's released and things of that nature, and put more stringent conditions that will actually secure his attendance in court. I think that will actually assist.
Advocate, the other issue here is the matter of Mafe's mental health, which has been a major subject of contention. We saw Advocate Dalimpofu yesterday, who of course is representing the accused, accused the state of furnishing the court with bogus affidavits proving Mafe's alleged mental health issues. Generally, is this how such a matter unfolds or is usually handled in these kinds of proceedings? When do we establish, or rather when should we be establishing the mental capacity of an accused to actually stand trial?
Yeah, no, it depends from case to case, but I believe that this issue that you're raising of his mental state is not going to go away anytime sooner. And also to use bogus in terms of the medical report is actually, I don't think it's the right word to actually use, because if it was done by a medical practitioner, the accused person himself and his legal representative might actually need to send the accused to be examined by their own medical expert to actually make a determination of his fitness to stand trial. But looking at the statement and the things that apparently the accused said in his statement, the demands that he was actually making, and the statements that are out in public relation to the demands, so I think request that inquiry to actually be conducted for the interest of the accused person by both the state and their legal representative.
Right, right. Lastly, Advocate, Zandile Mafe has also expressed his own intention to sue the state for wrongful arrest. I mean, he's insisting that he did not start the fire which destroyed the National Assembly and parts of the old Assembly buildings. Talk to us about what an accused or an applicant in such a position would have to prove in suing the state for wrongful arrest. I mean, how does one move forward with such a complaint?
Yeah, I think for him now, it's basically putting the cart before the horse. And I think the state is saying that they have a watertight case. And then that we are going to be able to see during trial how the state, in terms of the evidence that they have, can be able to convict him for the crime that he's accused of. And obviously for an unlawful arrest, you are the one that proves, the requirement is that you are saying that the arrest was unlawful, and you have the burden to actually prove that the arrest was unlawful and you were detained unlawfully. And there is a whole lot of cases from the Supreme Court of Appeal and the Constitutional Court that gives you the threshold in terms of the days and what you can be able to to get if you prove that indeed your arrest was unlawful. But in this case, the state is saying they have a watertight case, and we are not on trial. We are still on bail, and the state is going to call its witnesses on trial and see what kind of evidence we are dealing with from there. And then based on what the outcome of the trial, then a determination can be made.
Well, thank you very much. We are going to leave it there. That was legal analyst, Advocate Romeo Nthambeleni, helping us to